Good afternoon, everybody. I'm David Levy, Dean of the Duke Law School. Welcome to the Robert R. Wilson Lecture. Professor Wilson was a beloved professor of political science at Duke University for 50 years, from 1925 to 1975, and this lectureship was established by one of his students, Herman Walker, who went on to have his own distinguished career. At the law school, the Wilson Lecture has been given each year by the John Hope Franklin Visiting Professor in American Legal History. And how fitting that this year's Wilson Lecture is given by Adrienne Davis. My colleague Paul Hagen will introduce our speaker. Professor Hagen is a Rhodes Scholar. He received an MA from Oxford, his law degree from Yale, his PhD in history from Princeton. He knows a great deal. Paul.
As I was sitting waiting for this opportunity to speak, I was reminded by several people who came by that you all want to hear Professor Davis, you don't want to hear me, so I will have my remarks quite short. It is a genuine pleasure and honor for me to introduce our speaker today, Adrienne D. Davis, the John Hope Franklin Visiting Professor of American Legal History here at Duke Law School, and the Vice Provost and William M. Van Cleve Professor of Law at Washington University School of Law. Professor Davis received both her BA and JD degrees from Yale, and she then clerked on the Third Circuit for A. Leon Higginbotham, who was an extraordinary man. Noted jurist and historian of the law of slavery, managed to be a distinguished historian of the law of slavery while being a circuit judge, which is quite an amazing feat. She has been a member of the law faculties at the University of San Francisco, American University, the University of North Carolina, and has had visiting positions in the History Department at Princeton, the African American Studies Department at George Mason, and Vanderbilt, Alabama, and Toronto law schools. On a personal note, early on in her career, I tried to bring her here to Duke and both congratulate myself on my judgment and ability to spot talent, even if that was admittedly hardly difficult, and to chastise myself that it took so long to get her here. Professor Davis signs her emails ADD. A cursory look at her CV could give the impression that this is actually a confession rather than a set of initials. It is hard to understand how someone not cursed, or as my wife tells me, blessed with ADD, could find herself involved in so many things. She has been for 2 decades a prolific scholar on matters of race, sexuality, gender, and identity. She has been a builder of institutions and a facilitator of scholarly interaction. She has been a warm and supportive colleague, both within institutions and across fields. The cursory look would, however, miss the fact that for all the breadth and number of her responsibilities and initiatives, there has been a confounding reality that somehow she manages all of this with depth, innovation, insight, grace, and humanity. Now, to introduce humanity to the law of slavery is no mean feat. That effort can easily and mistakenly take the form of the softening of the edges of an institution that was at its core inhumane. That is not an error that Professor Davis has ever fallen into. Rather, her path-breaking and innovative work on the sexual and affective relations between slave masters and slave women has reminded us that individuals who operated the system and were its victims were also human beings who formed affective relationships, warped and distorted by the institution, but powerful nonetheless. The experience of living slavery and all of its contradictions of power, property, and sexuality, was far more complicated than any picture that might emerge from the mere formal study of law and its formal study of law and its categories might suggest. Professor Davis has explored creatively how those who inherited the world of slavery have explored creatively how those who have inherited the world of slavery need to respond and heal that inheritance. I have benefited greatly from her insights in the past, greatly benefited from her wit and humor. I look forward to reaping a new set of benefits from her insights today.
Thank you, Paul. I want to start by thanking Duke University and in particular Dean Levy and the law school for your immense generosity to me this semester. This time at Duke has been all that I could have dreamed. Much time to pursue my own work, but even more so, constant intellectual companionship and a sense of collegial esprit de corps and vigor that has been inspiring. In particular, I want to thank my students. I see two here, but I know that there are others here as well. I want to thank the students in my slavery seminar for your collegiality and for coming each week to grapple with me on these cases and these conundrums. You're the latest in 10 years of students who have really helped to produce this lecture today. When my colleagues and friends queried how I could possibly take a break from what is my very busy life in St. Louis to spend a semester at Duke, I advised it was an easy decision. Of course, the opportunity to spend time with old and dear colleagues, friends, interlocutors, and mentors in the Triangle was deeply tempting. And of course, having spent 7 years under Carolina blue skies, I loved the traitorous opportunity to spend time at my former nemesis. And I should also note that the Vice Chancellor of Admissions at Washington University isn't speaking to me anymore. I've tried to convince him I'm here as a spy, but more so than anything else, I was incredibly honored by the opportunity to hold the John Hope Franklin Chair for a semester. Dr. Franklin's work on free Negroes, the militant South, and of course, his monumental From Slavery to Freedom changed forever how we understand not only race and freedom in the South, but the entire field of American history. And beyond this, few people know this, but I considered Dr. Franklin a mentor. I believe we only spent 2 occasions together alone. When I arrived at UNC in 2000, I was a protege of Judge A. Leon Higginbotham's, and Dr. Franklin immediately reached out to me to ensure that I was doing well. I think I recall he took me to both lunch and dinner, and he was, in retrospect, determined to show me the range of what was then the culinary wonders of Durham. So we had lunch at Elmo's Diner. I think we had the chicken dumpling soup, and then a deeply memorable dinner at Nana's, where I am quite confident that we shared, at his suggestion, the pâté. And the evening was magical. I was in awe that an intellectual luminary and public figure could be so gracious, so generous, and so kind-hearted. I will never be the scholar or the human being that John Hope Franklin was, but I'm a better scholar and a better human being every day for trying. The intersection of slavery studies and the law is a fascinating one. Scholars are setting out increasingly rich and insightful accounts of how slavery regulated social relations in the antebellum South. Yet there remain some aspects of slavery's intersection with law that remain under-theorized even after all of this time. In particular, a question that continues to plague us is, what is the legal evil of slavery? Now, of course, we have intuitive senses as to why slavery was wrong. But when forced to articulate it, many still characterize slavery's evil as treating people like property. Now, we find this in both scholarly and in lay accounts. For instance, two influential slavery historians both incorporate this understanding in their much-cited titles. Kenneth Stamp called a chapter in his 1956 classic, The Peculiar Institution, a troublesome property. And more than 30 years later, Judge A. Leon Higginbotham Jr. entitled one of his most influential articles, Property First, Humanity Second. In addition, I've taught and lectured to generations of students and lay folks who, when asked about the depredations and the brutality of slavery, answer, well, they thought they were property. And in fact, in the memorable words of one student I taught at University of Alabama, who I challenged on this, she said, that's our default. I call this understanding of slavery the pure property paradigm. And in this view, slavery law and culture believed blacks to be chattel and treated them accordingly. Now, in my lecture today, I'm going to approach slavery through the lens of common law cases. And this may strike some as odd. Some of you will wonder why I would focus on cases that are about the technicalia of liens and mortgages and probate disputes, at the expense of the grand challenges mounted to slavery in Prigg versus Pennsylvania, Groves versus Slaughter, the Amistad case, or, of course, Dred Scott. Weren't the great legal battles over slavery fought here, where freedom and liberty and personhood and speech were at issue? In addition, some historians may claim that my focus on common law cases and rights recognition leads me down a Gramscian primrose path. In this view, also embraced by strict critical legal studies, rights are a sop, useless to meaningful welfare. Why then would I focus on these daily disputes, or what my colleague Laura Rosenberry calls the law of daily life under slavery? Yet I believe that the law of daily life under slavery sheds real light on the institution and, equally importantly, on the law. First, in none of these cases were judges called on or even able to abolish slavery. That was never on the juridical table. Rather, they were operating within the system, allocating and parsing legal abilities and disabilities. Now, certainly some were able to manipulate the law to achieve desired outcomes, including at times freedom. But wholesale eradication and abolition of the institution was never on the table. At bottom, these cases eviscerate the pure property understanding of slavery, and in the process push us to better understand not only that multi-century institution, but the operation of law today. So what do I mean? Let me start. Sawney versus Carter was decided by the Supreme Court of Virginia in 1828. Like many enslaved people, Sawney found himself auctioned at an executor's sale, sold to pay his deceased owner's debts. At his sale, Sawney had bargained with his new master to repay his purchase price in exchange for his future freedom. Now, while the court stated that proof of this alleged contract was not clear, the court did find that Sawney had given his master a wagon and 3 horses, plus wages he had earned from extra work done beyond that, compelled by his master. Now, it appears that although Sawney performed his end of the deal, and indeed following classic contract law, it would be difficult to explain Sawney's actions in the absence of a contract, his master refused to emancipate him. Sawney sued in equity, asking the court to enforce the contract and grant his freedom. But the court determined that equitable pleas for freedom were limited to cases in which the plaintiff had a legal title to freedom, but confronted some technical obstacles, such as a fraudulently suppressed will or a flawed deed. The court also noted that the facts of the case did not conform to the relevant law. Not only did state statutes limit manumission to slaves who had performed meritorious service, but it was also illegal for masters to permit slaves to, quote, go at large and hire themselves out, as Sawney had done, to earn the money to pay his master the wages, the wagon, and the horses. So despite his masters voluntarily entering the deal, and despite Sawney's performance of his end of the deal, the court refused to enforce their agreement, leaving Sawney enslaved to Carter. Now, Sawney is in many ways one of the more satisfying cases that we read in my slavery seminar. Now, of course, its facts are disquieting. Its holding is enraging. How can one person take such rude and complete advantage of another? And how can the law enforce such straightforward opportunism and brute exploitation? Even within the logic of slavery, this case seems outrageous. In fact, this case stands for everything we hate and despise about slavery today. And yet therein lies our moral satisfaction with Sawney. The case conforms completely to our views about slavery, justice, and the relationship of law to both of those. Now, what do I mean by that? First, the court's decision conforms to what many believe was the underlying legal logic of slavery, that slaves were property and hence were denied rights. And as I said, I call this the pure property paradigm. In this view, slavery's evil and immorality can be traced to the misperception that slaves were not people. And implicit in this understanding of justice, humanity dictates rights, and if the slave state had perceived and recognized that blacks were people, it could then have conferred rights on them, or at least gender equitable rights, treating black men like white men and black women like white women. Now, this designation of slavery's evil as lying in its designation of people as property enjoys traction on both the political right and the political left. As a trenchant defense of rights by its supporters, and even today, the occasional scholar questions whether slaveholders were deserving of reparations for the government taking of their property after the Civil War, to the manifold condemnations of slavery's oppression as treating people like chattel we see on the liberal left. But both miss, I think, how slavery's structures of power operated in more complex and subtle ways. Now, second, Sawney is a satisfying case because from our moral and our philosophical perch at the cusp of the 21st century, we can claim the confidence of knowing what the law should have done, what the slavery equivalent of a crusading Thurgood Marshall or William Brennan or J. Skelly Wright or Elian Higginbotham Jr. could have done in using the law as a tool of justice. The solution seems obvious. Uphold Sawney's freedom, which would be the antithesis of slavery. Now, this would adhere to what we desire from the law: fairness, formal neutrality, protection of individual rights. The judge should, as a matter of law or of equity, have recognized Sawney's right to enforce the contract and declared him to be free. Now, crucially, in enforcing these rights, law would have recognized Sawney's humanity, enhanced his welfare by freeing him, making an anti-subordination intervention, and in the process striking a powerful blow against slavery itself. In Sawney, the problem with the law is readily apparent. The pure property paradigm offends every expectation we have of the law. Students, remember Sawney and how easy it was when we read Sawney? That was easy, right? Similarly, Sawney makes the legal, just solution look easy. Recognize rights, which will also promote the welfare of the subordinated slave, and finally, through both of these, strike a powerful blow against slavery from within the system, well in advance of the Emancipation Proclamation and a war that tore the country apart. So far, so good. Our intuition that slavery's injury lay in its treatment of humans as chattel seems borne out. All is well within the pure property paradigm and its antidote, rights recognition, in light of Sawney versus Carter. But consider the following two cases, which I think significantly complicate our views. In Talbert versus Jenny, another Virginia case, also decided in 1828, Jenny's master, a B. Talbert, promised her that after she gave birth to 5 children, so that each of B. Talbert's own 5 children could enslave one of hers, he would free her. In 1792, Mr. Talbert gave the deed to Jenny and her son Moses to his own son, Charles Talbert, as collateral for a loan. Now, confirming the family's understanding that the deed was only collateral and not a transfer, Jenny and her son remained with Talbert Sr. Later, the Talbert family did indeed divide up Jenny's 5 children with the understanding that Jenny had fulfilled her end of the bargain, and she and her 6th child were now set free. And shortly thereafter, Jenny had a 6th son, Lorenzo, who also was treated as free, and then ultimately 2 more children who all lived with her as free blacks. Now, this situation continued after Talbert Sr.'s death, with Jenny's first 5 children divided amongst the adult Talbert children, and her last 3 children living with her as free blacks until 1813, when the son, Charles Talbert, standing on his deed, seized the 3 youngest children, claiming them as his property by virtue of the deed his father had given him in 1792. Jenny, who the family referred to as Big Jenny, he apparently had no interest in re-enslaving, and while we cannot know for certain why, this would certainly be consistent with slaveholders emancipating older slaves who were beyond the age of being productive and producing profits for their masters, and in the case of women, beyond reproductive labor as well. So Jenny sued to enforce Talbert Sr.'s promise, seeking a legal declaration of the freedom of her last 3 children. Now, unlike Sawney versus Carter, in Talbert, the Virginia Supreme Court upheld the manumission petition. It declared Jenny's children free based on a series of technicalities regarding whether the 1792 deed to Charles had been canceled, and also, importantly, a determination about the equities of the Talbert children's behavior towards each other and towards their father. The court made much of these sort of squinted at, winked at, potentially fraudulent conveyances among the family to shelter assets. Also of grave concern to the judges was an apparent family secret that Charles knew and was threatening to expose. Hence, much of the court's concern appeared to be the equities of the Talbert's children's behavior towards each other and their father. It did not, however, enforce the manumission based on Jenny's contract with her master or on the equities of Jenny's master's behavior towards her. In other words, the court explicitly avoided resting the freeing of the children on an enforcement of Jenny's rights, whether legal or equitable. Now, even though the outcome is far preferable to Sawney versus Carter, that is, here the court frees the slaves, Talbert versus Jenny is a far more, as one of my students characterized it, unsettling case. Return for a moment to the 3-part test I derived from Sawney. The right outcome, the just outcome, would be for the law to recognize rights, enhance the welfare of the slave by intervening in his subordination, and hence strike a powerful blow against slavery. And recall that in Sawney, these 3, rights recognition, anti-subordination, anti-slavery, were perfectly, and for lawyers, satisfyingly aligned. Not so in Talbert. First, Jenny wins her case, but not through recognition of her legal rights. The court's holding explicitly denies Jenny's capacity as a slave to enforce a contract and neatly sidesteps whether it is resting the case on her equitable capacity versus the species of equitable obligation the Talbert children owed to their father. Hence, Talbert yields a different outcome. The court upholds freedom, but it adheres to the same logic of denying slaves' rights. Now, second, if, as in Sawney, the measure of welfare is slavery's antithesis, freedom, then Talbert achieves that. It intervenes in the subordination of Jenny's 3 youngest children by freeing them. Finally, is this decision anti-slavery? Does it clearly strike a blow at that corrupt collaboration of law and politics? It is the outcome of this prong of the test that remains unclear. The court seems most concerned that Charles Talbert is behaving opportunistically but vis-a-vis his father's desire to set Jenny free after she reproduced a generation of workers for his children. And indeed, that is what black women did under slavery. Jenny's youngest earned their freedom because, in a paradox of brutal poignancy, their older siblings will labor for the 5 Talbert children in perpetuity. In our sister New World slave societies, a combination of climate, the type of crop cultivated, sugar versus tobacco or cotton, and also gender ratios took a toll on fertility and meant that the slave population was reproduced through continual re-importation through Africa. In the United States, though, fertility exceeded morbidity. Hence, black women like Jenny literally reproduced the slave workforce. And indeed, after 1808, when the legal slave trade was formally outlawed, enslaved black women's reproduction was the only legal mechanism for continuing slavery. So Jenny's master, in effect, gave her an incentive, not only to benefit his own children, but also to perpetuate the domestic slave economy more generally. Now, if the court had determined that Jenny's Faustian bargain with Talbert Sr. was enforceable, would this be the blow for justice that we might applaud today? In sum, while Talbert yields the outcome we want, welfare-enhancing freedom for 3 small children, it does so without recognizing the rights of the subordinated, and the holding seems actually to reinforce, rather than to dismantle, slavery and its grip on black women's reproduction. Consider a third case, Melinda and Sarah versus Gardner, an 1854 Alabama case in which a court refused to enforce a claim from 2 free black sisters, Melinda and Sarah, to inherit the estate of their father. Now, this gets a little complicated, so you guys really got to pay attention here. Their father, Tom, himself a former slave, had died intestate, without a will. So Melinda and Sarah thus sought to be recognized as his lawful heirs. So far, so good, very straightforward. Now, what complicated the siblings' claim is that they argued their father's estate included their 3 half-siblings, Oregon, Myles, and Rebecca. So Melinda and Sarah, free blacks, were seeking to enslave their father's 3 children from his second marriage. Now, importantly, for reasons I will explain, the case did not turn on Oregon, Myles, or Rebecca's rights to freedom. Instead, the outcome turned on whether Melinda and Sarah had enforceable inheritance rights, or what the court called inheritable blood. This determination itself turned on slaves' ability to marry and to have children deemed at law to be legitimate, the legal prerequisite to inheriting their parents' property. When the plaintiffs were born, their parents had been enslaved. And though subsequently both their mother and their father were emancipated, their father's relationship with their mother did not survive the couple's emancipation. They broke up before they were freed. So hence the court upheld the rule that the law does not recognize marriages between enslaved people. Hence their children can never be legitimate at law, and thus they are not entitled to inherit from either parent. What of Oregon, Myles, and Rebecca, though? Their mother had been a slave who Tom purchased after he broke up with his first wife. Tom had purchased his second wife, but never freed her. This meant that, like many white slaveholders, Tom owned the mother of his children, and he owned his children, who, following the laws of slavery, were enslaved like their mother. When Tom died then, his 3 youngest children became part of his estate, which his eldest children, Melinda and Sarah, were claiming as their property. Is your head spinning yet? Once the court determined, though, that slavery impeded Melinda and Sarah's ability to inherit, the court went on to conclude that Tom had died with no heirs at law and that his estate, including his youngest 3 children, escheated to the state of Alabama. Wait, it gets better. I know people thinking, oh no, not Alabama. Alabama, though, oddly and miraculously, had no interest in Oregon, Myles, and Rebecca and set them free. Yes. Now, as we did with Talbert, let's consider whether Melinda and Sarah versus Gardner conforms to the three-part alignment test we established in Sawney versus Carter. Now, first, the court denies the black plaintiffs' rights. It concludes that their parents' status as slaves continued to impede Melinda and Sarah's ability to inherit. Nor were Oregon, Myles, and Rebecca's freedom rooted in judicial recognition of their legal rights. Instead, as I've explained more thoroughly elsewhere, their freedom was due to Alabama's miraculous benevolence, the state's decision it did not want to enslave them. And to be really clear, had Alabama laid claim to Oregon, Myles, and Rebecca, the outcome would have been enslaved by Alabama or enslaved by Melinda and Sarah. Nowhere in this case was there judicial discretion to proclaim the three children's freedom absent Alabama's abdication. So far the case is looking like Sawney, law's denial of the rights of enslaved blacks. Yet, in Melinda and Sarah, although the court upheld crippling legal disabilities for slaves as a group, saying that there is no marriage and no inheritance among slaves, the outcome enhanced the welfare of individual slaves. Oregon, Myles, and Rebecca went free, satisfying the litmus test for an anti-subordination outcome. So finally, is this case anti-slavery? As in Talbert, I think this is a difficult determination. Individual slaves are freed, but the legal logic reinforces the absence of rights for slaves as a group. Again, the three children's freedom stemmed from denying black rights. Marriage, inheritance, and property all were denied slaves, and in this case, free blacks, by the Melinda and Sarah ruling. Instead, Alabama's charity ruled the day. Now, these three cases encroach on the pure property paradigm in a few ways. First, taken together, they suggest that judges often adopted far more complex frameworks than property to resolve disputes over slavery. Indeed, frameworks of slaves as property do not govern the outcomes in any of these cases. Sawney's freedom is denied because slaves didn't have standing to pursue such suits in equity, absent a flawed deed. Jenny goes free because the court uses equity to punish white children for bad familial behavior and suspected fraud. Oregon, Myles, and Rebecca go free because the court refused to recognize a slave marriage and they did not have inheritable blood. Now, of course, one could reason backwards and say that these outcomes were preordained because, after all, the law thought and treated them as property. But I don't think that's the case. And neither do my students when we discuss these cases. And I'll come back to this, but for right now, I believe these cases leave us with the sense that property is not a satisfactory framework to understand the complexity of slavery's interplay with the law. Samantha, do I have you? You got me. Okay. Second, and more importantly, these cases demonstrate that assessing justice under slavery is also a more complex task than the simplistic three-part antidote would suggest. Rights recognition, promoting slave welfare through intervening in their subordination, and anti-slavery sometimes aligned, but not always. In Jenny's case, her welfare and that of her children was vastly improved, but not through rights recognition. And even had the court held her contract to reproduce slavery to be enforceable, I think we would be loath to call that outcome anti-slavery. Similarly, in Melinda and Sarah's very troubling claim to enslave their sister and brothers, I have never encountered a student who wanted rights recognition in that particular case. But is this denial of their inheritance rights anti-slavery? No. So in this set of cases, Sawney, Talbert, and Melinda and Sarah, law had to respond to slaves asserting their rights. Now, I'll note here that there is also a corollary set of cases, ones I've given the 2-hour version of the lecture, and ones that intervene in the pure property paradigm from the other side of the domain the scope of the set of slaveholders' rights. These cases, again, on inheritance and fairly obscure probate matters, but also involving a conflict between a slaveholder and slave patrols, contested emancipations, and even a free speech case, show how slaveholders sacrificed immense rights, many rooted in property, in order to live in a slave society. Now, if according to the pure property paradigm, slave rights, welfare/anti-subordination, and anti-slavery align, then from the other side of the equation, recognizing slaveholders' legal rights should diminish the welfare of slaves and yield pro-slavery outcomes. Now, this, of course, assumes that slaveholders asserted rights primarily against slaves and that slaveholders' interests were aligned with the slaveholding states. But those cases end up troubling this easy, intuitive logic of alignment. And those outcomes, too, which I'm happy to talk about in Q&A, those outcomes, too, demonstrate the limits of the pure property paradigm. In sum, not only is it undescriptive, the pure property paradigm, I think, is an active miscue to how law operated under slavery. In fact, I would go so far as to say that that pure property lens obscures much of what was most important to understanding slavery and the regulation of not only slaves and masters, but also other stakeholders in the system, including free blacks and non-slaveholding whites. Now, much of recent legal history on slavery has tried to shatter the pure property paradigm. The work of legal historians Rebecca Scott, who works on Cuba, Martha Jones, who's doing a talk at the National Humanities Center later today on her beautiful work on slavery, our own historian Laura Edwards, Savolia Glemp, who's in the audience, Dylan Penningroth, and their wonderful graduate students like Samantha Smallis, have all issued profound challenges to the pure property paradigm, in particular by focusing on claims that slaves and former slaves made asserting their rights and demanding recognition by the law, and sometimes winning. And of course, legal historians have long noted that Southern criminal law quickly and easily noted that slaves were deeply human. And not only holding slaves criminally liable and capable of mens rea, but also parsing questions of self-defense, provocation, and even marital immunity for testifying. Neither juries nor judges blinked twice at finding enslaved blacks to be people subject to legal obligation and criminal law. And many have written about how law even took pains to ensure reasonably, relatively fair treatment of slaves in criminal cases, arguably far more so than in postbellum legal regimes. Thus, criminal due process rights for slaves were surprisingly cheap, as several scholars have noted. And yet, the pure property model maintains its grip. In slavery scholarship, in legal case books, I was talking to Professor Marilyn Forbes, who teaches animal law. She was telling me about some of the first chapters in her animal law case book, which are about slavery. In Joe Singer's absolutely wonderful case book on property, we see in all of these case books, slavery trotted out as the prime example of people as property. And of course, in everyday discussions, people continue to default to the evil of slavery lying and its treatment of people as property. Even incredibly thoughtful scholars, who I hold in the absolute highest regard, have difficulty breaking out of this mold. To wit, Thomas Russell, who has done phenomenal, groundbreaking work on the mechanics of slave auctions and sales and the disturbing breadth, he really uncovers the disturbing breadth of legal and social institutions implicated in that nasty market of sales of humans, has this really fascinating debate with property scholar Jeannie Schroeder on whether a Blackstonian or a Hofeldian framework of property better captures U.S. slavery. And part of me, I was reading and I was so caught up. I said, oh, this is so great. I love the Hofeld. I thought, wait a minute. It's still rooted in the property framework. Why is it so tempting to articulate slavery's baseness and slavery's depredation as a matter of property? And I don't mean to suggest I'm right, everyone else is wrong, everyone else is somehow tripped unthinkingly into the pure property paradigm. I have fallen prey to this in my own work, in which I've characterized enslaved black women as the sexual property of not only white men, but of Southern society. And if you see 12 Years a Slave, you will see this played out in vivid, vivid color. There are real signals that suggest the legal blame would lie in property frameworks. Now, a partial explanation, I think, is the predominance of constitutional law in both legal and popular understandings of slavery. And I know this is anathema for me to say at a place like Duke, where it's just a wonderful, wonderful place filled with the best of constitutional law scholarship. But when they think about slavery in the law, many people turn reflexively to constitutional law, expecting a tour through the famous or infamous Supreme Court decisions adjudicating slavery. And this makes complete sense, because we turn to the Constitution as the arbiter and the guarantor of due process and liberty and citizenship and personhood. Indeed, to the extent that most Americans are familiar with slavery in the law, it tends to be through the great constitutional cases, Dred Scott, Prigg versus Pennsylvania, or perhaps the fugitive slave cases, or maybe the slave ship cases, the Amistad case or the Antelope case. With those first three, Dred Scott, Prigg versus Pennsylvania, the fugitive slave cases, decided at the apex of sectional conflict, these decisions established a federal national view of slavery as legitimate and lawful throughout the country. And frequently, the judges and their political counterparts, and of course the lawyers themselves, routinely invoked and debated property as the reason why these outcomes were justified. And not surprisingly, Southern treatise writers such as Thomas Cobb, as well as pro-slavery ideologues, defended their rights in unrelenting property terms. And at least some Southern judges themselves, at times, embraced the property framework. Interestingly, my research suggests it was often the lesser judges who turned to this framework. The so-called better judges, the Ruffins of North Carolina or the Lumpkins of Georgia, embraced alternative frameworks that were still subordinating but not rooted in property. But I would concede that a superficial reading of the statutes, the cases, the treatises, the political rhetoric, it reinforces the pure property paradigm. But I think it would be a mistake to reason from politics and public law backward to a universal take on law under slavery. Instead, I've tried to suggest a line of cases, those governing the daily lives, interactions, and negotiations of whites and blacks, that complicates the pure property paradigm and suggests the need for more complex and thoughtful understandings of the function of law under American slavery. What else might account for these cases? Well, many things. I'll give you a list. Paternalism and its converse or its corollary, dependency. Moderate Southern liberalism, kind of an early version of that. And as my colleague David Koenig has encouraged me to explore, its support of a sort of a dissenting common law tradition. There's Marxist materialism, which focuses on the economic interests of the plantocracy and law as an instrument in battles over the form of labor and production under slavery. There's what I call the consolidation hypothesis, that the cases can be explained by attention to interests specific to the demographics of time and region. There's also, of course, brute racial supremacy, gender supremacy, and class supremacy. There's even a retroactive application of Derek Bell's interest convergence hypothesis that I toyed with for a while, in which the outcomes can be explained by whether the interests of the subordinated and the ruling class converged or diverged. Now, all of these are worthy, I think, of exploration, and all offer real insight into how the law was operative under slavery. But here's what's really going on, I think. At bottom, of course, all of these cases, public and private, criminal and civil, inheritance suits, freedom suits, at bottom, they are all about power. Now, this should be so obvious. And yet the fact that we turn reflexively to property and not to power to understand slavery's legal machinations is telling. What if Stamps and Higginbotham's groundbreaking work had been entitled A Troublesome Power, or Power First, Humanity Second? Would this have helped to showcase the consistent yet highly unpredictable wielding of brute power under slavery? I don't know. As Joshua and Rothman said at a panel we shared at the Southern Historical Association last week, it was actually a response to Samantha Small's really wonderful paper. When we see these unrelenting efforts to control and subordinate people, it is tempting to cast that as property. But that is not what it was. Property was merely the conceptual bucket, the socially accepted and persuasive way of masking and legitimizing extreme control, extreme subordination, and the most brute form of power. And of course, the law was instrumental in this achievement of what came close to total power. Instrumental not just in the sense of necessary to its achievement, but instrumental in that judges did complex gymnastics every day to manipulate law to address the varying and at times contradictory needs of appeasing slaveholders, non-slaveholding whites, the slave state, and even occasionally their own consciences. All of this begins to answer a question that people often ask me, and with which I will conclude. Why teach slavery in a law school? Isn't it a history course? Because I tell them at bottom, slavery is about the rule of law. In fact, for many of my students, especially those who do not take international law classes, this course is their opportunity to engage in what every lawyer should know reflexively, what the rule of law is and why it is crucial to democratic society. Characterizing slavery's massive moral failure as property is tempting. My colleague and mentor Jamie Boyle's work on property in the context of commons and the internet has pointed out the seductive draw of concepts we can understand. Here, that people were property. In some ways, it would be deeply reassuring to believe that slavery resulted from a misperception, an accident of perception, because that would be deeply rectifiable, and the solution appears straightforward and easy to embrace and administer. Don't treat people like property. Yet these cases suggest that we cannot fully account for the interplay of slavery and law without a thick account of power and its licit and illicit role in post-Enlightenment liberal democracy. Central to this is the rule of law. If we articulate slavery's brute evil, its base immorality in these terms, in our aspirational goals for the rule of law as an instrument of justice, only then will we guarantee that slavery has been, once and for all, put to death. Thank you very much. Questions? Yes, Professor Boyle.
I've heard the 2-hour version of this, and I liked it too.
You heard the 20-minute version.
So is the problem? Let me be the devilish interlocutor. Is the problem that slavery isn't property, or is the problem that property isn't property, or rather that property isn't what lay people think property is? Mm-hmm. Students come to law school thinking they know what property means, and by the time they leave their first property class, they look at their sneakers and don't even know what their legal relationship to them is. As soon as we offer them Blackstone's sole absolute despotic dominion, and then point out that Blackstone spent the rest of his book saying that never existed and could not exist. It wasn't just that it didn't exist, it was conceptually impossible. To be a property owner is to acknowledge one who stands above you, the sovereign who guarantees your property. As soon as you start to do this, you find immediately counterclaims. There are limitations on your property, limitations formed by other sole despots. All of the complexities and contradictions that you use in the slavery context to say that we have to go beyond property are also already in property. So is it enough to say that I find your conclusion compelling, that it's not enough merely to say, here's this legal category and there's an end of it. But do the contradictions within slavery decisions, particularly the ones which you didn't talk about, the rights of masters who sometimes wish to emancipate their slaves, and the law is caught between acknowledging their property, suzerainty, or acknowledging their desire to end slavery, and both of those desires, it basically makes the judges' heads explode. Is it the contradictions alone that get us to your conclusion, or is it the contradictions plus some other set of assumptions about the nature of law? Or nature of power, I guess.
There's a lot in that. I'll say this. Professor Boyle and I go back a long way. He still treats me like one of his students. He's treating me like one of his students. So I'd say I want to make two moves, right? I'd say I want to make two moves. I want to, on the one hand, get people to understand that, yes, this was property in its most instrumental form. Property as a lens or a framework, or perhaps just a mask for asserting control and dominion over something. Okay, so that's the first move, absolutely. Although the slaveholders and often the judges would try to assert the more pre-early Blackstonian vision than the vision that Blackstone himself actually kind of asserts. But the second move I think that I want to make is that the legal system understood deeply that this instrument of controlling people was fundamentally different than controlling objects or animals, right? So in that's the conflation, right? So when you find some of the lesser Southern judges or Thomas Cobb saying, oh, they were chattel, they were personal property, right? Everyone understood that they were neither chattel nor were they personal property. Instead, they were using property as a way of asserting and controlling an entire group of people, which I think they understood was fundamentally different than controlling your sneakers. So it's both of those moves I'm trying to make. Does that sort of answer your?
That answers the question.
Okay, good. Yes, Mr. Weiland, one of the students in my class this semester.
Happy students in your class.
Thank you for saying that.
To take it.
Thank you.
So would you like to talk about how the power relationship with slaves differs from the power relationship between husband and wife? Patriarchy?
It's a softball because we've discussed this a little bit in class because judges went back and forth, and this is when you really do see judges copping to the fact that they know slaves aren't property. So you see judges at times, Judge Ruffin, most noticeably talking about whether the master-slave relationship is analogous to the tutor-scholar relationship, the husband-wife relationship, the master-apprentice relationship, all of these being status relationships that obviously involve human beings. So to say that the master-slave relationship would be analogous is for them to admit, obviously, that they do not see slaves as property. Like, at no point are they saying, owner cow in any of that. So we haven't talked about this so much in class, but so I'd say on the one hand, absolutely the judges see it as analogous in the sense that they're status relationships in which there's a clear hierarchy, master over slave, husband over wife, and that they are deeply invested in the fact that this status relationship is good for all the parties involved, and again that it's very, very hierarchical, and that part of the status relationship is to fix legal obligations running both ways that cannot be altered by contract. In that sense, I think that they're very similar. And we've talked in class about how judges frequently draw on the domestic analogy of, our family, black and white. I treat my, slaves just like I treat my white family, and everything is good and harmonious. And, law should not intervene in my family relationship, and it should not intervene in my relationship with my slaves. And perhaps, my favorite analogy that I think I did mention in class, one judge, in looking at a case involving slave rape and why the law didn't recognize rape as a crime when committed against enslaved women, said, I think sincerely, perplexedly, well, how could we recognize rape as a crime against enslaved women? We don't recognize it as a crime when it's committed against our wives. But not in the way that you might think. I mean, so his point was, law can't intervene in these harmonious relationships. That being like Hansley versus Hansley. So in that sense, yes, there's a lot of overlap. But the relationships are fundamentally, absolutely different. And I'll just set out maybe 2 points. So one of the things I continue to like about Orlando Patterson's social death denomination of slavery, it's a real old school denomination. A lot of people hate it. One of the things that I continue to really like about that is he characterizes slaves as genealogical isolates at law. They're people who cannot make claims on society. They cannot make claims on the other intimates in their lives, their family, their friends. They can't make claims on the state. Everything is mediated legally through their master, right? And that is not true of wives. Wives are not genealogical isolates. Wives continue to have meaningful, legally recognized relationships with their extended family, with their children, with their parents, and that plays out in very powerful ways socially and culturally. So sometimes, given my research, I look at, well, how do white wives respond to this sort of structural sexual subordination by their husbands of enslaved women? Some of them would just, they'd pick up for 9 months and go back to Savannah or back to their hometown, and there would be sort of this complex negotiation of when and whether they were going to come back. So that is a set of social capital that even married white women had that certainly enslaved people did not. And the other thing I'll leave it at that. There's a lot more I could say about that, but I'll sort of leave it at that. Yes.
I enjoyed your analysis. I'm just wondering, do you think the way you define power sort of better explains slavery than property? Would that analysis work outside of the United States, where we had such a body of history of judicial intervention and a strong legal system? I mean, do you think in Brazil or Cuba, the Caribbean islands, or in the Arab countries where they had slaves, that slaves would somehow have legal rights that would maybe explain?
Yeah, I'd say absolutely. I think the power framework still captures what was going on, but it's the role of law that profoundly shifts. So I would say that in almost every slave society, certainly let's just say New World slave society, there is a profound struggle, not surprisingly, between the enslaved and the master class, plus everyone else out there as well, over power. Right? And that law is frequently called on to intervene and sort of allocate the power. So I've sort of described how I think it operates in the United States. It operates differently in other slave world economies, where slaveholders may be trying to extract, again, as much power out of the relationship that they can, but law or statutes, or in some of the countries, very intriguingly, the Catholic Church, comes in to intervene and to sort of ameliorate some of that brute power that you would see the individuals trying to exercise. So I'm really trying to do is not sort of say law is just the instrument of power, but law becomes the mediating force in the struggle over power. And the United States, I think law becomes largely corrupted and seized by the slaveholding class. Less so, I think, in some of the other slaveholding economies. Does that satisfy your question? Yeah. Although they were brutal in their own ways, right? So that they had, far greater rates of many of them, death. So, depending on what your measure of welfare is, again, right, is the measure of welfare rule of law, is your measure of welfare, freedom or morbidity, it's hard to measure, I think. Thank you for that question. Samantha.
I enjoyed your talk immensely. Of course, you know why, because it's very relevant to my work. And I'm still thinking through some of the questions that I have, but I'm wondering if, as scholars, the reason why we have relied upon the property paradigm is because of the way in which these historical figures talked about property, particularly in regards to slavery, right? Because when I think about some of the cases that I refer to, particularly Ruffin and some of the other
State
cases
versus
in
man,
time, right? Those individuals use terms like absolute power and authority, like end quote.
Right.
Those are their words.
Wait, say it again.
About property.
Absolute power.
Power and authority. Those are their words when they're talking about property. So I'm wondering, like Ryan, you asked, like, why property? But I'm wondering if the way in which they're talking about property in relation to slaves is inherently different than the ways in which they're talking about other property, and perhaps we haven't really parsed that out.
Right. So I actually had a whole section in here for you, Sam, about state versus man. I took it out because of time. So Sam's going to come and share with my class. They don't even know this yet. She's going to come and share her really wonderful paper on the Charleston Workhouse with my slavery class. And we can all talk about, because they've all read State versus Man. But so State versus Man is arguably, apart from the constitutional case, this is arguably the most famous slavery opinion. It's authored by one of the great North Carolina judges, Judge Thomas Ruffin. And it's not about property. It's not about property. It's about a man who has leased a slave from a woman slaveholder. He's leased a woman slave named Lydia. I think her name was Lydia. He and Lydia are having a fight. She's resisting. She's running away. He shoots her in the back. And he's prosecuted criminally. The white guy, the leasing guy, the stand-in slaveholder, is prosecuted criminally for assault and battery against Lydia. And the jury convicts him. the jury convicts him, and then Judge Ruffin comes in and overturns the jury's conviction and has, I don't have the exact quote, but he says that the power of the master must be absolute to render the submission of the slave perfect. There is nothing about property in that. There's nothing about property in that case. There's nothing about property in that sentence. What we get from Ruffin, this is why I kind of had it in here, but I took out, what we get from Ruffin is exactly what I'm calling for. It's the most bald articulation of the need of masters to completely subordinate this group of people. There's nothing about property there. Go back and look at the opinion again. And then when he reinforces it with all that sentimental, kind of Harry Beecher Stowe rhetoric and everything else about how sad he is about and everything else, but he talks about the slaves as people, these creatures, and how they're happy or sad, and the masters are X or Y or Z. There is nothing about property in that case. And so the fact that you remember, not just you, a lot of very, very, very smart slavery scholars remember that as a case about property goes back to my question of why would we take a bald, to me, very satisfying articulation of what slavery is. The power of the master has to be perfect to render the submission of the slave absolute, right? Why we think about that in property terms instead of what Ruffin tells us, power terms, right? So we'll talk more. Yes?
I wonder if you find a distinction between the federal and state courts. I'm thinking of the treatment of the person property distinction in some of the areas like marine salvage, where the slave transported would be viewed as having a will, having some power of his or her own. In the enforcement of the Federal Boiler and Steamboat Inspection Act, where the federal court, even in Charleston, South Carolina, treats slaves as persons for that purpose. And Chief Justice Tawney on circuit in Richmond in 1859, faced with the application of Dred Scott in his statement about property, hedges and says slaves are subject to the Federal Postal Larceny Act, and suggests that in Obiter that it would be wise for the federal prosecutor to divert those cases in the future to the state courts.
Interesting.
Which are able to deal with them, rather than seizing the property of the master for 3 years imprisonment in the federal penitentiary in D.C.
The slaves would be imprisoned.
Pardon?
The slaves would be imprisoned?
Yes.
Interesting, fascinating.
It's a fine and up to 3 years imprisonment in the federal or in any jail, but they would be sent. She would have been sent. Slave Amy would have been sent to the federal penitentiary in D.C., which achieved fame with the Lincoln assassinators who were hung in the yard of that penitentiary.
Well, I've not looked at the particular two cases that you referenced, and I'll have to look them up immediately right after class. But right after the lecture. But but I want to say that you're absolutely right that the complexity of the interplay of the federal system with the local system is played out with sort of Byzantine complexity and nuance, as we see not only in Tawny sort of saying, well, I'm going to send this back to the local courts, but of course in the entire question of national politics and the ultimate compromises and the debates between the slave states and the free states and everything else. This is all being constantly fought out. I will look at those two cases because in sort of the quote grand constitutional cases that I think most people look at that are in most of the constitutional case books, it gets so fought out in terms of property. It's almost as though the Supreme Court justices, I think they just, obviously they're smart enough to know that it's not really about property, but it's just easier. It's just easier to let the property framework go forward. So I'll definitely look at the other ones that you suggest. Now I have looked at some of the cases I think where you really do see this conversion of slaves into property are where people are literally asserting property rights enslaved literally. So the insurance cases, right? The insurance cases are quite fascinating ones. Or what was the other one that I was going to reference? Oh my goodness, there's another really fascinating set as well. insurance case. And I think you referenced these as well, where people took out mortgages or had liens in slaves. Or my personal favorite, when they were adjudicating widows' dower rights to their dead husband's property, it would turn on whether slaves were categorized as real or personal property, because dower only attached to real property and not to personal property. And there was a pendulum swing as to whether slaves were considered real versus personal property. So sometimes you'd have the master would have manumitted the slaves, and the widow comes in and says, no, I want to re-enslave them because I'm asserting my dower rights. It all turns on whether the slave is real or personal property, and it's just, again, just absolutely Byzantine. So I thank you for, kind of really focusing on some of the areas where we really literally might see it at work. So thank you.
Thank you.
Thank you.